Welcome, everyone. Thank you for making time to join our webinar. Thank you so much for coming in. As you're being admitted, we were told that there's a standby of about 100 people. We are so happy. So we are waiting for you to just join in. Welcome, everyone. We'll just allow a minute or two for people to join in, and then we'll start. Thank you again for joining. Thank you for those who are joining us on Zoom and for those who are joining on Facebook Live. Welcome to the webinar. Right. I think if I could ask the panelists to just have their videos on, we'll start, and then we'll have the other participants join us as we go ahead. Great. Okay. So thank you for joining this webinar. We are starting now. It's a webinar where we are discussing the rewriting of African feminist judgments, African judgments from feminist perspectives, and we'll also launch a collaborations platform, the Let Us Collaborate platform. The purpose of, before actually I go to the purpose of the webinar, there is important housekeeping that I need to announce, which is that the webinar is happening in 3 languages. We are speaking in English, the original, but we also have French and Portuguese translation. The French translation is by Joy and the Portuguese translation by Naima. Thank you so much, Joy and Naima, for joining. The important thing that has been made as a request to all of us is that we speak slowly, slower than normal because of the translation, to make sure that we are all following each other promptly. To access the translation, at the bottom of the screen, there's an icon, and you can select the language to engage with us through. And remember to mute the original audio so you don't have double conversation, because the translation is happening simultaneously. The flow of the webinar is that we'll start with part 1, which is the launch of the Let Us Collaborate platform. We'll have a brief presentation, and then we'll open up for question and answer briefly. We'll then go on to part 2, which is the African Feminist Judgments rewriting project that we are popularizing today. And we'll have a conversation between the original partners that launched the AFJ project around 2018, and we'll hear more about it. And then we'll hear from our panelists who are actually part of the African Feminist Judgment Project on the judgments that they are rewriting. So to start off, I want to welcome all of you who are joining again. And to introduce myself, my name is Dr. Ruth Nekura. I work as ISLA's legal director. I'm a feminist human rights lawyer, and I'm really happy to be here. ISLA is a feminist Pan-African organization that works on the continent to develop jurisprudence on women's rights and sexual rights. We also work to strengthen civil society's capacity to develop strategic litigation. And we are very interested in developing a pool of feminist lawyers to do this work on the continent. I'll now go ahead and introduce the panelists that we have with us. A lot of them don't need introduction, but I think because the session today is quite Pan-African in the sense that we are having conversations with people who are interacting with our work for the first time, it's really important that we know who's joining us today. So we have first Dr. Martha Gayoye, who's a social legal scholar with strong commitment to do grounded research to advance social justice. She's currently a lecturer of law at Keele University in the UK, and she's a member of the African Feminist Judgment Project. This project, as we'll see later, seeks to rewrite landmark judgments from Africa from feminist perspectives, and Dr. Martha is contributing 2 chapters, a rewritten judgment and a case commentary. She has more than 7 years experience in the legal profession in Kenya, and before she commenced her PhD, she had worked for the government in public service for over 6 years, and also briefly at the National Commission on Human Rights. Her professional experience lies in constitutional and public law, public finance, devolution, and human rights. We're also joined, actually, before I go on, maybe I can just ask you, Dr. Martha, to say hi, just so we can hear your voice, and you can tell us maybe why you're happy to be here, actually.
Hello, everybody. Thank you so much for Dr. Ruth Nekura and team for organizing this. I'm very happy to be here. And this project, we've been working on it for a while, so it's really great to meet again to talk about it. Thank you very much.
Thanks. Thank you so much, Dr. Martha. Okay, so we are also joined by Emma Wabuke, who's a great colleague and a friend. Actually, Emma holds a Bachelor of Laws from University of Nairobi and a Master of Laws from Harvard Law. She's an advocate of the High Court of Kenya and is currently enrolled as a PhD candidate at University of Cambridge, the Center for Multidisciplinary Studies in Gender, as a Gates Cambridge Scholar. She's demonstrated extensive experience conducting in-depth research, consultancies on varied human rights issues, such as reproductive health and gender-based violence. She's also a member of ISLA's panel of experts. Emma, would you like to just say hi and tell us something about why you're excited to be here?
Hi, thank you very much, Dr. Nekura. I'm very happy to be here and to see some of my colleagues and to continue this, I think, very important conversation on African, Feminist Judgments Project. Thank you.
Thanks, Emma. Thirdly, we are joined by Sibongile Ndashe, who's my director at ISLA. Sibongile needs no introduction. She founded ISLA in 2014, and she has over 23 years experience in strategic litigation. Having initially studied at UWC, the University of Western Cape, she went on to clerk for the South African Constitutional Court in the Chambers of Justice Krigler and Oregon. She has a lot of experience, and that has actually culminated in this question of how do we bridge the gap between how things are and how things should be, how the law is and how the law should be. Later on, Sibongile worked for the Women's Legal Center, leading the work of women's property rights and access to resources, and later for Interrights as the lead lawyer on equality in Africa. Eventually, doing the work around the first case that came before the Commission on Women's Rights, the case against Egypt. So she really does have a bird's eye view about how the law and courts in particular can be used to advance human rights of women and people whose rights have been violated on the basis of their sexual orientation, gender identity, and expression on the continent. Hi, Sibongile, do you want to say hi and tell us why you're happy to be here?
Hi, so thank you for inviting me. And I am really happy to see so many people. But I think this is a question that has preoccupied not only us here in Africa, but it's a question for many feminists who try to engage with the court, with courts. So really trying to imagine with other people who have done this work or who are looking to do this work is something that I'm excited about.
Thank you, Sibongile. And finally, we are joined by Professor Ambrina Manji, who also definitely needs no introduction. She's a renowned global scholar who I would describe as, having the ability to forge really unique partnerships to advance social justice across the sectors. She's held several academic posts at several universities, Warwick and Kiel. She's also been a visiting fellow at University of Cape Town and Dar es Salaam, a global teaching fellow at Melbourne Law School, and Dame Lillian Penson Fellow and the Institute of Commonwealth Studies at the University of London. Professor Ambrina's research is focused on law and society in Africa. It is strongly interdisciplinary and collaborative. She's published extensively on the history of African legal education, on law in African literature, on women and the law. She's collaboratively co-published on political science, history, development studies. She's served as president of several associations, has represented them in several spaces within the arts and humanities sector, and also law. She's a co-editor of top-ranked journals and a long-term member of editorial boards. She sits on international advisory boards and academic working groups, councils. She's the co-founder of the Cardiff Law School's Path-Breaking Global Justice Pro Bono program and has advised a number of international organizations on land issues. So, she has several collaborations, which include actually today's focus on the African Feminist Judgment Project. So welcome, Prof. Would you like to just say hi and what excites you about this conversation today?
Thank you so much, Ruth. That's a very kind introduction. It's really lovely to see all of you here today. I just want to express my thanks really to Isla and to all of you for keeping the flame of this project alive. We started this conversation some time ago, but life has intervened in the meantime, and we've lived through a global pandemic. We've been separated. We've not necessarily had the momentum behind us that we thought we might have. But I'm really so grateful to you for keeping faith with the idea of this project and seeing so much of its potential. And I think that its potential actually becomes clearer the more that time passes. And I'll say a little bit more about that perhaps later, but it's just to express my thanks now to all of you.
Absolutely. Welcome and thank you so much. Welcome to our participants. We really do encourage you to introduce yourself in the chat box. Let us know where you're joining from. Let us know your thoughts as the conversation continues. Then when we get to the end, we'll have an opportunity for you to unmute and ask questions. So welcome. So again, to reiterate, the purpose of today's webinar is twofold. First, we'll start, the twofold. First, to popularize the African Feminist Judgments Project, to have a conversation about it. We've received a lot of interest as we were sharing this poster and speaking to partners about the upcoming webinar, and also to launch a collaborations platform, which is connected to the African Feminist Judgment Project. And hopefully at the end of the session, we hope to clarify how people who've expressed interest can participate both in the African Feminist Judgment Project and also the Let Us Collaborate platform, and to see how these two can connect. So on for part one, I'll now ask my colleague Cynthia to project the slide where we'll speak a little bit about the collaborations platform, and then we'll go ahead. Thanks, Cynthia. Right. So So this is the Let Us Collaborate platform, LUC, which I'm very happy that even as the invite went out, people have already reached out to us to, they've engaged with the website. It's an online platform that facilitates NGOs, civil society actors working on women's rights and sexuality rights on the continent to engage and collaborate more effectively. So we'll give a bit of a background onto it. Right. So how this online platform started, or the idea behind it really, is in response to a need to design a space that can enhance collaborations among activists, academics, lawyers, and other people who are working in the social justice sector. And it actually emerged as a recommendation from a strategy consultation that ISLA hosted around 2017, 2018, which really just recognized that sometimes our efforts can be fragmented, siloed, operating in parallel, and that can frustrate the impact that we are all working towards. So in response to this challenge, and this was a consultation that was hosted by ISLA, but in partnership really within a coalition in itself called the Bridging the Gap Coalition, which includes Kenya and Dula Omar Institute at the University of Western Cape. And this coalition was funded by Amplify Change to do work around SRHR. So the initial focus of this need was looking at the SRHR sector. It's one of the sectors that really has a lot of diverse actors that hardly intersect and collaborate to develop a shared understanding of how social change comes about and how the work can have greater impact. So, but as the work continued to happen in conversation with other partners and coalitions, it became clear that this challenge is consistent across all other areas of work that we do, not just, SRHR. And so within several discussions with partners, the need for a collaboration space, a platform to enhance how we collaborate, keep projects alive, and share knowledge and information became clear. So the scope was broadened, and it's been a labor of love that's been supported by a lot of partners. And most recently actually motivated by the African Feminist Judgment Project, because again, it's a collaborative project. And so we're supported to sort of the final push to get the platform out. And so here we are. We'll have a brief video just telling us a bit more about what the platform is. And we'll also see some initial testimonials of our partners who've started using the platform and what they think potentially it could be impactful for. And then after that, we'll have my colleague Cynthia to speak to us just a bit about what onboarding or using the platform looks like. And then we'll take a few questions and wrap up the first phase. So over to you, Cynthia or Mubin. Hi, my name is Ruth, and I'm here to welcome you to the Let Us Collaborate platform, abbreviated LUC. LUC is a platform that's designed to support coalitions, networks, collectives that work on women's rights and sexual rights in Africa to collaborate more effectively. Through LUC, we can enhance these collaborations among different civil society formations that work on gender equality and sexual rights on the continent. LUC also simplifies the processes for different social justice actors to seamlessly collaborate. For instance, human rights defenders, activists, academics, lawyers can work together on strategic litigation, research, advocacy, capacity strengthening initiatives, and even resource mobilization. LUC also facilitates cross-learning and scaling up of civil society organizations' interventions to reach a wider audience. We know that across the continent, there are activists, social movements, and practitioners that are working on groundbreaking initiatives.
And so LUC enables these actors to develop a shared analysis of how social change comes about, which we believe is important. By collaborating, we can amplify and strengthen our efforts for greater impact. So welcome, sign up. Just to let you know what you'll expect when you get on the platform, there is a landing page which provides this information about what LUC is about and the objectives. You'll also see some featured collaborations. These are networks or coalitions that already exist on the platform, and you can read about them and see which ones spark your interest. And then once you sign up, you have access to a private collaborations platform where you can then sign up and join or apply to join any of these coalitions. And then you can also form your own coalition. If you're organizing around an issue, you can form a coalition, and ISLA will provide back-end support for the platform and also coordination support to make sure that you're collaborating effectively. So welcome, and let us collaborate.
Hi everyone, my name is Dr. Mariam Kamunyu. I'm a feminist international human rights law lawyer, and I'm currently working on the proposed African Feminist Rewriting African Judgments Project, and very excited to be doing so. So the thing with feminist rewriting judgment projects is that they're typically done by academics, and the danger of having projects being done or led by academics is that sometimes they can tend to be siloed and restricted to these academic spaces, and then end up not really extending or making an effective contribution to social change. And so to mitigate that risk, I was very excited when I heard that ISLA went ahead and established a Let Us Collaborate platform. So it's an online platform, and I think this platform has really great potential in terms of mitigating that sort of gap that exists between the academy and these other actors such as human rights defenders, women's rights organizations, social movements that are actually connected and most times are leading in efforts towards litigating for women's rights in this continent. And so I'm very happy to hear that we have a space now where we can collaborate on projects as academics and as social movement actors, and we can therefore have like a shared analysis on good practices that can be impactful. LUC also creates a bridge that is really important in terms of allowing the lived realities and experiences of women, of girls, of sexual minorities to come through and actually influence how we think about rewriting feminist judgments. And so very excited to be a part of this project and really looking forward to participate in the LUC platform. Thanks, bye.
The biggest opportunity presented by the Let Us Collaborate platform is to create synergies between non-traditional partners. Take the African Feminist Judgment Project, for example. This particular project has the opportunity to bring about different voices from diverse fields such as academia, the judiciary, and the legal practice to come together and rewrite judgments from an African feminist outlook in a way to contribute to ongoing legal reform on topical issues. Secondly, I believe that this particular platform would be effective in furthering future collaborations as it provides a one-stop shop for diverse opinions wishing to contribute to ongoing conversations around different legal issues. The Let Us Collaborate platform can be effective in facilitating further collaborations as it presents an opportunity to be a one-stop shop for diverse voices within the legal field. Indeed, this particular platform can ensure that a diverse voice can not only access important relevant materials to any specific topic, but also contribute in existing conversations around the said topic by inputting their own opinions and well-researched information about it.
The Let Us Collaborate platform, I believe, is going to be a very useful platform for sharing information and making it easy to collaborate between different networks. For us, particularly as members of the litigants group, I think it's going to be useful for us to share information amongst members and the steering committee and to work on tasks together, fix meetings, do our scheduling, share documents and information. I think it's a very good development pioneered by ISLA, and I look forward to seeing how this can help us as a group to better collaborate.
Right. Thank you so much, Mubin. So I just want to capture a few things for purposes of translation. One is that the video, gives a background in a context and some of the utilities potentially for the LUC platform. It is our desire to have the video with French and Portuguese interactions as well, in however that iteration would look like. For instance, as our partners from Francophone and Lusophone Africa engage, we'd love to hear your perspectives on how you find the platform, and also gather your testimonials on how the platform is helping you to collaborate more effectively. It's currently translated in French, the platform, but we are very open and keen to have it translated to other languages as well. Also to say, yes, I think I've mentioned the testimonials part. So I'll give it up to Cynthia just for about 5 minutes to give us a bit of a breakdown on how to log on, and then we'll go on. Over to you, Cynthia.
Thank you, Dr. Ruth. Hi, everybody. So basically, there are two ways to sign up or to onboard onto the LUC platform. And the first way is ISLA can register you onto the platform. So we'll use your name, your surname, and your email address. And once we have registered you, you'll receive a notification email with an invitation link. And so when we send you the email to just let you know that we've registered you, you will maybe have to go into your junk email, because we've noticed that some domain actually block the notification email from LUC. So it goes into your junk mail. And on that invitation link, once you click on the invitation link, it brings you to a registration form where we collect and we store your personal information. And we will also set up a password for you. But once you've logged in, you will have the opportunity to change your password. And then another second way to onboard is to actually sign up on the website yourself. But I think there's quite a few people that have already done that once they received the banner for this webinar. So once you've registered on the platform, there is on your right-hand side, on the homepage on your right-hand side, there's a panel that actually walks you through the entire platform. You get the Get Started. It walks you through. It gives you a guide and overview of the platform. You have a guide of the different collaboration, of the user profile and also the administration. And as you go on, you will see that it strikes through every single guide, but it gives you the possibility of going back and looking at it again if you feel like you did not understand something properly. So there's just a simple button as you go through. There's a simple button, just helps you click next. It gives you, like I was saying, it gives you a tour of the entire platform. And once you're done and you feel like you need to go through it again, you can always do that at your own time.
Thank you, Cynthia. Thank you so much for that. As we mentioned, the project is now officially on the pilot phase, LUC, and we are really keen to follow through with those who are interested in joining the ongoing projects that are there. Once you're interested in a coalition or a project and you apply to join, the idea is for the coalition to decide what's the vetting process that allows people to join. So, and this is about, making it a safe and a secure online platform as well. And so we'll have an admin team at the back to review and approve memberships. And also, if you're keen to, like we've received requests, people would like to form a coalition, you're also welcome to send that to us and we'll provide the support. Just to say here, really the intention is for intentional collaborations and not really a general Facebook sort of where there's people who are watching what's going on and those who are really active. It's the design for the LUC platform is for coalitions that are intentional and members of that coalition that are intentional as well. That could already be existing, and you are wanting a space to just help you keep all your knowledge sharing at par and keep the project going. You can set up meetings, a calendar, set up tasks for people in terms of what you want to do, goals, objectives, and then keep each other on check. So I'm noticing that our time has gone, but perhaps on the chat box, let me ask that you type in any questions specifically for the Let Us Collaborate platform that you have, and then we'll definitely be able to respond to these questions. For the unmuting and allowing people to take the floor, we'll do that at the end, but please do type in on the chat box questions about this platform specifically. Special thanks really go to Reformar for supporting us to have Portuguese translation on this webinar today, and to Joy, as usual, for being awesome with the French translation. For those who've joined us, we have both English and French and Portuguese and French translation, and you can tune into the channel. So I'd like to move us now to the next phase of this webinar. And before I do that, to invite the panelists to come on video again, and to make an apology ahead of time for Sibongile. Thank you for making your time, Sibongile, to join us. Who will leave us a bit earlier for a parallel commitment that really we couldn't shake. But we are happy to have you now at the beginning of the session. So we are switching gears now and to start talking through the African Feminist Judgment Project, but of course with the LUC platform in mind as well, which we are declaring as being launched today. And so to open us off for this publication, I'll start with you, Prof. Ambrina. Could you share with us a little bit of background for the African Feminist Judgment Project, how it started and what are the partnerships that were involved, and the vision, broadly speaking?
Thank you, Ruth. So casting my mind back to the beginning of our conversations about the need for this project, it seems to me we've already come a long way in the sense that this platform will allow us to resolve some of the potential kind of weaknesses that can inhere in a project like this. And I think the main one is precisely that if it's allowed to develop as a project which is predominantly academic, then it's cut off from its really important roots and what it really, and from the potential that it has to bring about social and legal change. So a platform like this, I think, is a really welcome development for those of us who are based in the academy and who certainly predominantly thought about it in the first instance as an academic project. So to give you some background, the African Feminist Judgments Project is part of a kind of suite of projects. You know, it has sisters all over the world. So there are very well established feminist judgments projects in a number of jurisdictions. And when we came together, and Isla has been, you know, was there at the conception of this idea, when we came together, our sense was, you know, there was a really urgent need to bring together a group of people interested in the conceptual driver and the intellectual work involved in a feminist rewriting. What would that mean and how would it look? But we never wanted that project to be disconnected from social movements, from feminist campaigns, from strategic work, because our work is far too urgent. You know, since this project has begun, there has been more and more evidence of how urgent it is that we defend the few gains that we have relating to women's rights and to the rights of, for example, sexual minorities. I'm Kenyan and I work on Kenya, and I worry terribly about the future loss of those few gains that we might have made for a number of reasons. You know, in relation to reproductive rights, in relation to sexual minorities, I worry enormously about the assault on rights that we're faced with. And I think there are enormously important coalitions to be made between long-established feminist movements and movements for minority rights. And I would include in that, you know, the rights, for example, of minority indigenous people. So the project, in my mind, the project has kind of grown conceptually beyond something that's driven by academic curiosity to something that I think can really contribute to the sort of work to which we're all committed, the sort of work that Isla has been, you know, absolutely committed to from the start, including in relation to amicus briefs that it's submitted that have had great impact. The other thing that strikes me, just listening to the conversation in this session, is how central all of this work should be to pedagogy. And to teaching, because I really think that, you know, when we started the project, we had a number of kind of targets in mind, and one of the ones we talked about at a meeting that we held in Nairobi was, you know, how do we bring on board critical friends, colleagues from the judiciary, who we would want to start to influence by putting this material into their hands. So one of the really interesting discussions, Emma and Martha will remember this in Nairobi, was, you know, how does a feminist judgment, a rewritten judgment, look? So different sister projects have taken different approaches. Some of them have done really creative and important work in broadening out the idea of a feminist judgments project way beyond what you might, you know, traditionally, conventionally think of as law, into the arts, into humanities, into creative expression. Some of them have rewritten their feminist judgments in ways which are, bear very little resemblance to a kind of traditional judgment. And that I think is very exciting and creative. One of the debates we had in our group in Nairobi was, how far do we want to stray from a conventional judgment and what it looks like? And I think we were pretty much unanimous that actually, given that we want to get this material into certain hands, including to feminist judges, feminist practitioners, we actually wanted these judgments to be recognizable, really legible to practicing lawyers. We wanted to, in some ways, be reasonably conventional in the way that we rewrote the project. So we were going to follow all of the legal conventions in terms of structure and style and approach and reference to precedent and so on. And I think that's a decision that I would stand by. So we're very clear who we want to get these, for whom we're doing this work. One of the things we haven't really thought about as a group, and I think it was something to revisit, is the potential for pedagogy that's inherent in this project. So how do we teach feminist judgments? Where in the curriculum do we fit them? How can we sneak them in? How can we train our students in these ways of working and thinking? Because I think that's very, very powerful. And I think the platform may give us precisely the kind of structural wrap that we need to do this. So I'm very interested to hear from colleagues what they think is the potential for doing that. But my mind remains really very open about how we use the Feminist Judgments Project and for what, strategically, how we make sure that it's accessible, that it's referred to, that it really brings about change. How do we give colleagues confidence to use the rewritings, to think about the rewritings, to challenge the rewritings, to contest them? That's entirely, for me, conceptually and intellectually, that's the point of this project, is not that we present our rewritings as settled rewritings, but that we challenge our colleagues, rewrite and rewrite and rewrite. That's the idea, that all of these things should be contested and contestable. But I remain absolutely firm that our commitment is to support those working at the front line for legal change when it comes to women, to sexual minorities, to people whose rights are very clearly under assault and about to become, I think, even more directly under assault in a number of jurisdictions about which we know. So I'm very open to hearing ideas, to thinking about how we develop this project and where we go next, to provocations from all of you.
Mm-hmm. Thank you so much, Prof. And just from that background and context, Bongile, I want to bring you in here just to reflect on what Prof is saying, and also why, and I think of ISLA as this organization that's working at this intersection of research, knowledge production, engaging with even curriculum and things like this, but also very much the intentionality to work with social movements and other broader actors. So why is this African Feminist Judgment Project so important? And specifically, how is it useful as a strategy for achieving social change?
Thank you, Ruth. When we were invited, to be part of the collaborators, I think it was right. I think we were only 3 years old as an organization until 2018. And we had a lot of ideas, some of them attainable and others not, on what we wanted to do. We wanted to save the world. So I think there's quite a lot of things that have changed, since then, kind of reality check about what is really possible. But for us, it was always about trying to ensure that the ideas that we have around social change are able to travel across, disciplines. So we are practitioners. Although we provide knowledge, we are not exactly, an academic institution. It's knowledge that is very limited. It's knowledge that is very targeted. And so it became important to us to look for other players and other people who can support the work that we do. And so academics are one, but we were not only looking at legal academics. We wanted to have more people who can come, and support our work and help the ideas that we have to travel and inform the work that others are doing, and also so that we can be influenced. But as feminists, we've always known that change is not always linear. So we would make progress and then we will always go back. And I think that's always a very sore point, I think, for people who go to court and then sometimes win, and then you see the things that you have fought for kind of reversed. But we have struggled. There was a decade, I think, the late 80s and early 90s, where when we are telling the story of African feminist litigation, the Sarah Longwe cases in Zambia, the Unity Dao cases in Botswana, and other cases, that what had become clearer then when we were celebrating those achievements is that courts really understood formal equality, that you cannot treat men differently from women. And we have stagnated. So there are more issues, so we are more aware, and we are going to court because we are saying we now want you to see substantive, equality, that it's not only a difference in treatment that we are looking at. And we do see that courts really do struggle to get this, whether we are talking about violence as discrimination when looking at violence against women, or even looking at issues like women's land and property rights, that the furthest that courts have been able to take it is that, and legislatures, it's that, of course, women have to inherit, like men. But we have been playing this ping pong game when it comes to issues like division of property at divorce, because it's still, if you want us to be equal, so you take what you brought in there, and that's what equality means, which is still taking us back to the formal equality. So we do go to court, and sometimes we come back, with decisions that we do not want, because that is where we are stuck, the inability to really understand or get to where we want the equality jurisprudence to get to. So the rewriting project is an imagination project, that this is what a judgment can look like if it is written, using a feminist lens and analysis. Because many times there is a way in which feminists are talked about like they are part of the right-wing movement, that feminists do not understand the constitutions, that if we were up to feminists, we would be castrating people, sending them to jail, for all, for long periods of time. And part of it is because in the legal circles, and what the judges are saying, it's that our hands are tied, looking at what the law says, what the law is, there is no other decision, that we could have come to other than this decision that you do not like. So if you are properly applying the law, this is where the law, will take you to. And part of what this project is about is saying that actually, if you had applied the constitutional framework and international human rights standards, it would have been possible for you to get to another conclusion, right? And so part of it is really about understanding how the law continues, to place women at the margins of the law. So we are not only rewriting judgments, but we are rewriting women into the law we are rewriting women in a way that helps to change the social scripts that the law refuses to see us, you know? And so if our question, the work that we are doing at ISLA is about trying to answer why is this law the law? Because we want the law to be changed or the law to change, then part of rewriting the decisions is helping, you know, the courts and also other legal commentators, you know, to understand that another decision is not only possible, but it is necessary, you know, in order to get us where we want to go to. So we want to untie the hands of the judiciary. So we are really interested in legal academics. And of course, I sometimes feel like I do have petty, you know, like petty reasons for doing this. And one of them is to shame people who say they are using the law when they are working outside of the law. And so by rewriting it and saying this is what the Constitution says and this is what international human rights standards are about, then that's why we're also writing these judgments. And it's also a way to vent, you know, the frustrations. You know, sometimes, depending on how the judgment is given by the court, whether they read the whole thing or they just summarize it, you sit there as a litigator and you imagine, I can't really make sense of where we are going with this decision, you know, are we winning or are we losing, you know, where is this person going to tank us, right, until you get to the end of the decision. And as you're sitting there listening to this or even reading this decision when it is written, you really can see that the person had a struggle, you know, to get to the conclusion, you know, that it could have gone either way. It's not like they didn't get the point, but something stopped them from going there. And part of it is really helping them to get to the right decision. We often say that, you know, the courts, when you engage with courts, there are two things, views that people have. Sometimes we want courts to lead, you know, social change. So we are saying you are not here to mirror the bigotry, you know, that exists in society. You are here to make sure that the morality of the Constitution is what leads, right? So we are looking at courts as forerunners of social change. But there is also the other view that courts sometimes are comfortable to ratify changes that are already happening in society. So they don't want to see themselves as having gone too far, you know, by making pronouncements that may not necessarily be liked, you know, by many people in society. And so that's the reason why, to always help them, you know, get there. So we are writing this, mostly people who have got time to do this have been people in academia, but we are doing it for the people who are writing briefs. You know, sometimes when we do the work with the feminist lawyers that are a part of our network, we are saying, look at your favorite judgment, and imagine if you don't have the submissions, just imagine what it was that they gave to the court, you know, that allowed them to get to this decision. So these are the other reasons. So when we are looking at these judgments as something for lawyers, it is something to also help them to help the courts get there. So that's why it was important for us to be a part of this project.
So good. Thank you, Sibongile. I was just taking down quotes that I think are so powerful. Like, we are not simply rewriting the judgments, literally, we are trying to rewrite women into the law and to enable the hands of judges to be untied, help the judges untie their hands by it really being an imagination project. And I really like this, linking to what Prof was also saying about thinking about pedagogy and what's happening in the teaching space, because I find that's where conceptual battles are won, you know, at that space of pedagogy. So if those are the people that are going to be judges and going to be practitioners, then I really see alignment there. A follow-up question to you, Prof, is in the context of the feminist judgment projects, and you know, the other sister projects that exist, and now this specific one, from your experience, what do we want to achieve from this feminist judgments project, and what would it take us to get there? What do we need to get there?
So I think there are a number of things. So speaking as an academic, for me, the fact of being able to listen to Sibongile, for example, I mean, just in this forum, you know, even before we get to the business of the concrete rewritten judgment, even to have the opportunity to have insights such as the ones we've just had from her is immensely valuable. So for her to say, take your best judgment, your favorite judgment, and think about what the submissions would have been that allows the court to go there, is immediately immensely powerful for an academic, because it's just it's putting a question that I kind of have in the back of my mind but haven't articulated absolutely on the table from the point of view of someone who has done the day-to-day work of getting those submissions before a court and seeing the results that the outcome that you can achieve. So for me, already this room is showing the power of this project, that you can put people together who all have the same ambition, but because they work in such different domains, actually don't have the full overview. You know, Sibongile can see things that I simply can't, because as an academic, I don't have the insights into the work of getting litigation underway. Similarly, I hope that academics can bring to the project the kind of maybe conceptual clarity, but also kind of robustness that academics, I hope, are committed to, that we can be partners who will contest and push and rethink and historicize. You know, when you say, Sibongile, this is the constitutional framework, maybe the academics will say, yes, and it's a constitutional framework that was reached because of these particular struggles. And that story might help us think about how we can now employ the constitutional framework, historicize, contextualize, those sorts of skills that academics have. So for me, it's about all of us from our very different domains being able to work together and to teach the judgments, sure, of course, to use them as a teaching tool, but also to use the skills inherent in rewriting a judgment as part of our teaching. So to impart to our students the kinds of insights that Sibongile has given us there about what it takes for a court to decide whether it can or cannot make a particular leap. What is the political context? What is what do we need to give them in terms of the legal materials, but also when do we start to judge whether the political and social context has changed sufficiently that this is a good moment to try to push? And when do we accept that, yes, this isn't a full game, but it takes us some of the way towards where we want to go? Those are really important things to be teaching our students, I think, and really important ways of getting them to think about the law as, you know, strategic, as politically nestled, as, you know, requiring us to really think carefully about when you move and when you don't.
Okay. So I think, Sibongile, you have already imagined for us what this project needs to look like beyond the academic product, but indulge us a bit more, what else is the kinds of outputs we're looking at here beyond an academic product or infusing a curriculum? What other strategies could we use and how do we get there? You're muted, Sibyl.
So one of the things, and it's been mentioned before, it's we have to work with different actors. And I think this is one of the things that have preoccupied us at ISLA, that legal change or even litigation itself is not just what happens, in the courtroom. So we say that what happens outside of the courtroom is just as important, as what happens, inside the courtroom, because, litigation for many people, it's still that idea that, look, folks, you can all step aside. The men in black coats have arrived, they'll fix things, they'll take care of things, for us. And so the thing is to remove this idea of men in black coats when we think about litigation. And we start imagining the power, that social movements have and should have, because we know that just as our recent histories are showing us that trickle-down economics is a scam, this idea of trickle-down kind of impact from litigation is another scam, right? We don't get social change. We can get law and policy change that a statute has been amended, kind of struck down, but there is a lot more that needs to happen, especially in this work that we are doing on women's rights. We know that court decisions do not end the work. So when we have constituents that are invested in the outcome of litigation, invested just like us, so that it's not only the lawyer's thing, people who are able to say why we are going to court, how this is actually going to change, their lives, the people who are affected. So when we are talking about movements, we are not talking about branded t-shirts and people being bussed to courts, as the face, of the issue. We are talking about people who are engaging, in this work. So we've talked about this collaboration between academia and us practitioners. And so the other way for this to live is these conversations. So we are saying to people that, yes, this judgment that you have heard about that has angered so many people is actually incorrect. You need to believe us. We are not the Supreme Court of Appeal, but this is not how it ends. I mean, there is an example of a case here in South Africa, State versus Togo, from last October, which it's a rape case. And in that case, the judge overturned a conviction, a rape conviction, on the basis that the accused person had a reasonable belief that there was consent. So even though the complainant had not consented. So there was a lot of this conversation, so where we had legal analysts coming in and saying, oh, the judge was correct. This was the only way, to do it. So the public narrative about what rape is and what consent is affected, by this decision, does this mean that men can go around reasonably believing that there is consent, even if the person had said no, right? So to be able to rewrite this decision, to critique this decision, to point out that this is where they get it wrong, and this is how the law, if they had applied, you know, so one of the things that we have said in our criticism of the decision is that the court focused on the accused person's right to fair trial and erased the constitutional rights of the complainant, you know, so no right to equality, freedom from violence, dignity, and all of that. In a public conversation, so even if people are not lawyers, but who are taking part in this conversation, it is important to say that when you are talking about this issue, one of the things that you need to see in a decision, in a judgment, is you need to have a contextual analysis that this is a scourge, it is prevalent, it is about power. And then as you go in, then when you apply the law to the facts, you already have set out the nature of the problem that we are trying to respond to. This is an important thing, that when you see a judgment that does not locate this conversation and it's just dealing with the facts in abstract, then you are likely, you know, to lose it. So part of the outputs that we want to see is that even as we rewrite the judgment, it becomes a source of conversation, you know, in many spaces that we occupy, that says, yes, maybe we want to change rape laws for different reasons, but on that day, the judge had what was required for him to reach a different outcome. So we want to be able to do conversations with social movements. We want to have this conversation even with service providers. You know, when you look at issues like intimate partner violence, there are very few people who are able, who feel comfortable going to report these kind of cases. But if you have someone who is providing advice, there are many people who would say, just find a way to deal with it, but I do not think that the police are the people who are going to help you, you know, with this. So one of the things that encouraged us as lawyers and activists in South Africa was that these are cases, you know, that the court, that the police thought were worthy, you know, of investigating, and the prosecutors took these cases on, right? So when we get a negative decision, knowing how hard it is, then as we rewrite, this is part of the context that we need to be able, you know, to put there. So this is information for service providers. This is information for many people. And it also becomes about how different actors package, you know, this information that says, actually, the law can be this. Actually, the law is capable of giving us just outcomes, you know, that we do not have to sit with this idea that justice and the law are distant, you know, cousins. So we have to have a conversation with many actors as possible in order to shift the social script, you know, and change the public narrative around some of these issues that we are going to court for.
Thank you so much for that. Yes, Prof, go ahead.
Ruth, if I can just make one intervention,
Yeah.
which is to build on Sipangilo's point, and I think it's a really excellent one about our interaction with social movements. So one of the things I think we need to guard against is how much we, as lawyers, we center legal strategy. Sometimes there's a danger that the move to litigation actually takes the wind out of the sails of social movements. Sometimes because social movements become very focused on the legal strategy, and it is one way of sure, it's one way of making gains, but we've seen time and again that social movements have to be able to have the space to develop other ideas about bringing about social change that don't just center law. And I think as lawyers, sometimes we're kind of not deliberately, but we're complicit in the use of the law to take the wind out of the sails of social movements, and we allow the legal claims to be so central that it dampens down other kinds of claims that social movements also want to commit to, for example, economic redistribution, redistributive politics more broadly. We center that legal gain as the main gain. And so Sibongile is absolutely right. Working with those social movements is also about recognizing the many domains of across which they're struggling, and the sorts of gains that they might be able to make, which are very far removed from legal ones. Then perhaps cementing those gains with a legal framework, but perhaps allowing some of those struggles to play through without, and it's difficult for us as lawyers to think about this, without any role for lawyers and legal practitioners.
Absolutely. Thank you for that. I think the main takeaway I'm really hearing is we don't have the full picture, which is a quote that actually I'm taking from you, Prof, today. And because we don't, then I think it's something Dr. Mariam said in the video, we need a bridge. We need a bridge for the different actors, whether it's judges, it's legal practitioners, it's service providers, social movements, law students, to engage, because then it provides an opportunity, and that's why I love LUC, for movement actors, social justice actors, to infuse even the analysis of what we are calling a rewritten judgment with the lived realities of women, of girls, of sexual minorities. Thank you so much for that reinvigorating session. And now we'll sort of swap a bit and go to hear about actual potential judgments to be rewritten from Dr. Martha and Emma. And I think I'll just start with you, Emma, to say if you could give the audience just a brief facts of, the case that you selected to rewrite and why you thought to rewrite this case.
All right. Thank you. Thank you very much. And quite enjoyed the conversation so far. I think I want to apologize in advance if you maybe hear some barking in the background. It's just my puppies enjoying the British summer a little bit too much. So I'm apologizing in advance, just in case they do that. But to start off, I think the judgment I've selected took place about 20 years ago, but really reflects a little bit about what Sibongile has highlighted with the recent South African case, a situation in which judges look at the facts in abstract without taking note of the social political context, and in that way end up with a conclusion that is that is discriminatory to some of the participants involved, in this case, women. So in this particular case, it's titled Dobler versus Sudan. And the setting of this case is the African Commission of Human Rights. The brief facts here were that university students from a university in Sudan, Ahilia University, attended a picnic, and then they were arrested for violating or for engaging in activities that violated public order. This particular case was under the now repealed public order statute in Sudan. What is interesting, though, and I wish to read out the so-called activities that violated public order, and they were described by the Sudanese authorities as, quote, girls kissing, wearing trousers, dancing with men, crossing legs with men, sitting with boys, and talking with boys. This picnic obviously had attendees who are both male and female, but the description of the offense was essentially targeting what the girls were doing or were perceived to be doing in that particular instance. And they were convicted under the public order statute, and they were sentenced to public lashing. This matter was then brought by Curtis Dobler, who's a known international human rights lawyer, before the African Commission. But the African Commission, and in this particular case, I wish to, I think, put more of the emphasis, or at least the faults, on the complainant rather than even the commission, because the complaint focused solely on Article 5 of the Banjul Charter, which deals with freedom from cruel, inhuman, and degrading treatment. And there was no conversation at all about the gendered nature of the offense. And this is where my rewrite seeks to make a credible intervention. In essence, this particular rewrite that I have will seek to address, of course, as I've pointed out, the gendered nature of the description of the offense, putting the blame on the women involved. And this particular nature of this particular description quite evidences, legally sanctioned gender policing and gender stereotyping. So my rewrite will actually seek to look at how Sudan, as essentially in many other contexts, women have been assigned certain societal roles, certain stereotypical roles that require them to act in a certain way, be passive, pure, and uncorruptible. And so this discriminatory state of affairs is reflected in the country's domestic law, that's a public order statute, but it is unfortunately not legally addressed by the African Commission. So in trying to do my rewrite, I will be guided, and I've been going back and forth about this particular point, but I think I have more or less settled that the best guiding point in conducting this feminist rewrite would actually be from standpoint feminism. So wishing to borrow from the ideals of specifically Black standpoint feminism, so works that are derived from scholars such as Patricia Hill Collins, where she provides that standpoint feminism is looking at women as the primary source of knowledge, that women, and in her case, Black women, are best suited to provide certain important reflections on social phenomena because they are the primary victims of multiple oppressions. In this case, therefore, I wish to borrow a lot from Black standpoint feminism, but of course injecting it with African feminism as well, and reflections that have been made credibly by social legal scholars in the African continent, such as Professor Tamale and Professor Oyewumi, to really discuss how essentially the looking at it, if we look at this particular incident from the perspective of the woman involved in this context, how then does it shift the conclusions that should be met by the particular court? So specifically, and trying to make it legally digestible, this particular rewrite, while drawing inspiration from a very, from a theoretically or a theory that is formed predominantly by academic scholars, will then transform, at least use standpoint feminism to look at how substantive equality can then be achieved. So almost transforming standpoint feminism as an academic theory into a more legally digestible concept called substantive equality. And to do so, this rewrite will seek to answer, I believe, two main questions, which is, what have been the women's experiences of their life situation in Sudan under the Public Order Act? And secondly, how does the Public Order Act, written in very gender neutral terms, advance gender inequality in its implementation? In other words, then how do we attain substantive equality in penal laws in Sudan? And so essentially that will be the concept, or at least the main thrust of my argument as I proposed to write a concurring opinion before as sitting in as a commissioner before the African Commission. I just wish to highlight briefly, I think, two main points about the procedural and logistical hurdles of this particular feminist rewriting. Now, some have already been, I think, mentioned by Sibongile and Professor Ambrina, specifically about how do we bridge the gap between legal academia, legal practice, and social movements, social movement, the work by social movements, which is something that I would seek to try and guard against, but I do not, to be fair, I do not have exact answers of how exactly I'm going to do that. But the other procedural hurdle is just that rewriting, the feminist rewriting of this particular judgment requires one to rewrite a legal question that was not addressed by the court. So essentially, how do we then merge the idea of bringing in, introducing as a judge, a question that was not introduced by the complainant? How do we sort of square that with the role of the court to play an adversarial or to take an adversarial position in this particular court? So, and one of the ways in which, through my research, one of the ways in which I think we could use that as a justification is essentially using a comparative human rights jurisdictions, or at least a jurisprudence emerging from comparative regional human rights bodies, which calls that you can actually expand certain, can expand conversations beyond what the complainant has brought about in the interests of justice, is often the terminology that is used. So again, I try to use, in answering that procedural question, I try to use this feminist rewrite in a way to help, I hopefully help commissioners before the African Commission know how to navigate around some very troublesome procedural waters. But the second logistical hurdle is that the public order statute has now been repealed. Before, in Sudan was repealed in 2019 following the removal of President Omar al-Bashir. So, of course, obviously, the biggest question then is, what is the purpose of a rewrite dealing with a law that has already been repealed? And I think in that particular, in that ways that the rewrite, I believe, would help precisely because the problems has not been sorted out, even though the specific illustrative statute has now been repealed. The question to which gender neutral laws have inequality in their results still remains. And I do believe then that still the rewrite is still relevant to respond to those specific questions. And that is my brief.
Thanks so much, Emma. And maybe just a follow-up before I go on is, so how do you think the rewrite itself will lead to social change? What do you think will be transformative about this specific rewrite in terms of advancing gender equality or social change?
I think it's the rewrite itself is not proposing new ways of, I think, new ways of thinking, or novel ways of thinking around gender equality. I think what the rewrite does is essentially try to elaborate on existing ways in which we can further gender equality. I think it's more or less settled that substantive equality is often better than formal equality. We are ensuring that it's not just equality in the law, but also equality of results is often a more it's a quotable statement, and yet the practice. And there goes the dogs. I'm sorry, but the truth is the practice, as Sibongile has pointed out, is not as it is not as accurate. It doesn't quite happen the same way. So what this rewrite is trying to do is essentially tackle the particular question at hand, which is how do we inject substantive equality, deliberately inject substantive equality in dealing with questions around gender neutral laws? And in that way, I hope to catalyze in some ways our legal change. In terms of social change in terms of how then there's further social changes, hopefully to then develop conversations in contemporary Sudan now, as of course upheavals still continue to happen as different actors try to gain more muscle in that political marketplace. There have been conversations about reviving the public order statute, or at least coming up with some relevant statute that deals with organizing public order, or at least ensuring public safety. And I think an intervention such as this feminist rewrite would hopefully ensure that that then, while redesigning a penal law, would then encompass certain levels of substantive equality, ensure that there will be gender equality as we pursue penal laws in that particular state.
Thanks, Emma. Thank you. So good. So I'm really just reflecting on what you're saying and what Prof had said around, we do want the judgments, as you've made the presentation, it can sound it is very technically, technical and legal. But it's perhaps about thinking what other outputs or formats we want it to exist in. So the tension being, we do want to maintain it in the conventional forms of the commissions, communications, decisions or judgments. And then perhaps this is where it's a good opportunity to partner with other social movement actors or feminist activists or organizations who can essentially rework the same analysis in a product that can facilitate access to other people who would want to engage with this analysis in order to trigger a shift in narratives or actually where social change happens. And I don't know what it is, that the law was repealed in the process, just shows us again that change happens at multiple levels. We know it's not, judgments that actually necessarily trickle down into change, and that it can happen through law reform and all other manner of ways. So I'll hand it now to you, Dr. Martha, just to speak to us a bit about the judgment that you're keen on rewriting. Tell us a bit about the facts and why you selected to rewrite it.
Thank you, Dr. Nekura. I think that I have the benefit of listening to everyone else. And so in my presentation, I'll also reflect on what everyone else has said as I go along. But my judgment is, it's commonly known in Kenya as Advisory Opinion number 2 of 2012. At the moment you say that, everyone knows what it is. But the subject matter of it is the 2/3 gender principle. Some people call it 1/3 gender principle. I prefer to call it 2/3 gender principle. It's in the Constitution of Kenya, 2010, and it basically states that not more than 2/3 of members of the National Assembly and the Senate and other public appointments should be of the same gender. So basically what that means, and why some people call it 1/3 gender, which in my opinion is not correct, is that it should not have it should have at least 1/3 of women, mainly because historically it's been men who have dominated parliament and executive and other public bodies. So it's called in the matter of the principle of gender representation in the National Assembly and Senate. So that's important in terms of the case because it was not so much concerned about other devolved units, the 47 units. It was centered on parliament. Of course, for the devolved units, it's important, but we'll see in a minute why it was concerned with parliament. So this case was filed in 2012 by the Attorney General to the Supreme Court asking for an advisory opinion. And in it, he was asking the Supreme Court to give an opinion on the question was on whether the 2/3 gender principle should be realized immediately. Now you're talking about 2 years after the Constitution had been promulgated in 2010. I say we, I have to confess, I'm actually Kenyan. So sometimes I'll say we, but I actually mean Kenyans. So Kenya was supposed to have the first general election in 2013, the year after this reference was filed by the Attorney General. In it, he basically says that he's very conflicted, he doesn't know what to do because elections are coming up and there isn't a mechanism for making sure that Parliament will not have more than 2/3 of, let's just be realistic and say men. But of course, the Constitution uses the gender neutral language. So, he perceived basically an inconsistency. He says that the Constitution states in no uncertain terms, and this is in Article 81, that there shouldn't be more than 2/3 of one gender. But when you go to the composition of Parliament, it's not exactly clear how that is supposed to be achieved. So basically, we have to wait until elections happen to determine whether there is at least a third of women. And so he, perceiving this inconsistency, he decided to ask the Supreme Court to give an interpretation of what that means. Does that mean that in 2013 we must have a third of women at least, or can it be later? Can we realize this rule progressively? And in his reference, you will also see, because I had the benefit of reading it, is you will see that it leans towards sort of it's interesting because it's asking the Supreme Court for an opinion, but at the same time it's leaning towards sort of considering progressive implementation. So that was it. But also the other reason was that there had been a number of court cases in the High Court concerning the same quota in the judiciary. There was a case about the judiciary as when judges in the Supreme Court were appointed. For the first time, there was that question of the quota. What did it mean? And there was basically a whole conversation going on, especially with women's rights activists, FIDA, Center for Rights, Education and Awareness crew is very much at the forefront, and they still are to this date, and many others. So there was something that was going on in the High Court before, I suppose, we decided enough is enough. I need something from the Supreme Court. And the reason why I chose this case is personal, because I appreciate the introduction you gave before about me working in the government for a number of years. So at the time when the opinion was delivered, I was a legal officer at the Commission on Revenue Allocation. And I remember when the case was in court, my boss then called me. I was in charge of in the legal department to advise the commission on things to do with revenue allocation, how revenue is to be divided between the national government and county governments and the devolved government, basically, but also any questions to do with revenue in the national government. So of course, the conversation around then was, if we have more women, if we don't realize this principle, then it means we have to nominate more women in Parliament, and then it means we have to spend more public money, and therefore we should progress this rule because we don't have money to pay these extra nominations. So I remember trying to argue against that, but that seemed to be the conversation around government at the time. And it was very frustrating for me, being the young feminist that I was then. So I decided to actually do a PhD on the 2/3 gender principle. And I'm very happy to say that I completed that with Professor Ambrina Manji as my external examiner sitting here. So, so that's the reason why I decided to write this. And reflecting on what others have said as well, the project, as Ambrina said before, the project has grown conceptually, but I also believe that even us as members of the project, we have also grown a lot in our own personal journeys in academia and professionally. So of course I left I'm no longer a practitioner, I am now an academic, but that is the background against which I decided to write this judgment. So conceptually, I have had conversations around the potential and limitations of using law to bring about social change. And I have reflected on this in my own PhD on what potential the Constitution has for enhancing gender equality, and what the limitations are. So for example, as others were talking, I was reflecting on Carol Smart's Feminism and the Power of Law, and she does reflect on these questions, that there is a risk, of using law. So you have to make strategic choices. What are you using the law for? And so I did reflect on these questions in my PhD. I can't say that I came up with all the answers, but right now I am thinking wider around gendered constitutionalism of the global South, which basically, and I'm happy that my colleague Emma is part of a special issue on that, what potential do constitutions have on being about gender equality.
Thank you so much, Dr. Martha. That's really, really informative, and we're excited to see what the rewritten judgment looks like, and to uptake it so that we can facilitate uptake in all of these various forms we are talking about, for legal practitioners, for lawyers who are drafting, for judges, for social movements, for feminists in general. So I see we have about 20 minutes to our time running up, and I want to open up the floor now for questions. I'm really just enjoying looking at the chat and the conversations that have been going on there. And I want to start us off just by one question that came from Brenda Combo, which I think is really important to mention upfront, about the importance of recognizing that there is no one feminism, and we are talking about feminisms and feminist perspectives. And I don't know, Brenda, if you'd like to unmute just to make the point there, because we totally agree with you that it's about feminist perspectives, not one, and definitely not feminism. Would you like to come through? Meanwhile, other people who want to speak, you could just raise your hand and we'll queue you up. Over to you, Brenda.
Thank you so much for the invitation to speak, and thank you for sharing this very exciting initiative. I'm very happy to see you, Dr. Ruth, and also a few other familiar faces, Emma. So my point was just, I was just curious about how you grapple with this very complex diversity of feminisms in the work that you do, how you reject this notion, as Ruth rightly said, that there's a singular feminism, and in the rewriting process itself, give space for that diversity, recognize that diversity, grapple with it. I just was curious about how you're doing that, but thank you.
Thank you so much. I don't know if Emma, Dr. Martha, you want to come in? Or Prof, if you're still here, Sibongile as well.
I'm gonna come in here to just say, like, for me, I'm taking the cop-out position in this particular question, and I think I've been, like I said, when I was presenting, that I've been going back and forth as to what guides me, because I would settle on one thing and then you'd read another book and then it kind of throws you off and you wonder whether to settle on that one instead. What made me, or what drew me at least to standpoint feminism, is that it's not necessarily a theory that advances, a concrete aspect around interpretation of who a woman is or things like that, like other other traditional frameworks of feminism. It's simply a unifier of feminist epistemologies. And so in that particular case, that is why I personally will be guided by standpoint feminism, drawing inspiration from Black feminist, of Black standpoint feminism, but really trying to anchor it around also how certain other people have internalized or have had discussions around what African feminism also means. And taking specific notes, and I think this is something I have learned today, so I'm not going to pass it off like I had always thought about it. It's also, I think, injecting conversations by social movements, specifically in my context, which is Sudan, and how social movements themselves describe or understand, community-based organizations understand the concept of feminism, and injecting all of that, but using standpoint feminism as my epistemological input in that particular context. But that's just me, and it's not really going to engage in so much of the theoretical debates, because I'm not very strong on that point, but I do agree on the diversity of feminisms. And so instead of looking as to what substantive theoretical sort of angle I will take, I will instead be guided by the epistemological angle instead.
Okay, Prof, do you want to come in here? How are we in the project just grappling with this?
I completely agree with Emma that I think that each rewrite of a judgment will be from a particular feminist perspective, depending on its author. So, and I think what's important is to be explicit about that and to describe, to contextualize your own feminist, the tradition that you come from, and how that has helped to shape the way in which you've rewritten the judgment. And I think what would be very valuable is for our project to be as diverse as possible in terms of the different traditions of feminism to which we adhere. But fundamentally, a feminist rewrite project arguably is a liberal feminist project, you know, because it engages with the law in ways which assume the possibility of social change through the legal system. There's a part of me that would want to make the argument that actually, if you were to wish to use this, to use your rewritten judgments to put into the hands of judges, the legal profession, and so on, as a tool, as a way of showing them, supporting them to bring about legal change, then actually the most favorable way to approach it is to take as conservative approach as you possibly can. You know, as careful and as moderate as an approach as you possibly can. Because realistically, you know, feminist judges with the best will in the world are not going to adhere to a kind of radical feminist position, or at least they're not going to be able to sell that position to their peers in their court. So, you know, there's an argument for taking as gradualist and as careful an approach as you possibly can, as a way of making that rewrite useful to those you want to put it into the hands of. But there is nothing to say that you can't have in your mind or write a judgment, right judgment which adopts a radical feminist position and explicitly say that and show why it's useful to do that. And it's precisely, I think, the diversity of the kinds of approaches we take. None of us, in the project, I think, would agree on any one feminism, partly because where we could be differentiated by whether we're in academic positions, which jurisdictions we come out of, our own personal histories, but also, I think, generationally. I think there's a kind of generational divide. Older and younger feminists will take different approaches and positions, and I think that's valuable, but I think the task is to make that explicit in each rewrite.
That's really good. I think I really loved what you said earlier on as well, that there is room for critique and that we are open to a rewrite over rewrite, over rewrite. And that, while we are positionally largely informed by, intersectional feminists analysis in this sense as our way of shaping the way we do it, it's really from a place of acknowledging and a lot of reflexivity and openness to critique as well. So that's great. Thank you so much for that. Is there any other question? I'm not sure if I've seen a hand go up, but as we are waiting, I've seen there are comments from Tina in the chat box. And Tina, if you're still with us, I'd really love to welcome you to just make a contribution. Also just super grateful for Reforma for providing the Portuguese translation. Over to you, Tina.
Hello, everyone. I hope you can hear me. Thank you. Thank you for the opportunity to somehow make this possible for Portuguese speaker people and have access to such an interesting topic. Yeah, my name is Tina Lorizzo. I'm the director of Reformar. We do work on human rights applied to criminal justice through applied research, training, and advocacy. As I commented on the chat, we are particularly interested at the moment on this topic as we are conducting a research that looks at few sentences of judges in Mozambique, sentences related to women that have killed their partners, and following the penal code in Mozambique, homicide is punished between 16 and 20 years of imprisonment. Killing a partner, ex-partner, husband, etc., is actually an aggravated circumstances. So it's actually punished between 20 and 24 years. So we are looking at this sentence, noticing that there are no, and at the judgment as well, notice that there are no actually, not even questioning from the judge about any gender dynamics of the cases. And beside this, we are analyzing the legal framework, and as you were saying, we found the legal framework even more limiting, considering that a judge has not really a maneuver of not imposing anyway the prison sentence that is between 20 and 24 if the wife has killed the husband, and so we are very interested in this, and we hope to further collaborate. And thank you very much. This has just been very good. And I welcome the student, the candidate of the Legal Training Center that I know that are attending the event. So thank you.
Thank you so much, Tina. I see we also have a hand from Nerima. Welcome, Nerima. Thank you so much for joining. I love you so much. I mean, knowing that you're on leave and that you made time, it's amazing that you made it go through.
No, thank you so much, Dr. Nekura. It's really lovely to see you all. And Martha, Professor Ambrina, Sibongile, Emma, I hope you're all doing well. Just wanted to contribute because I am a member of the project, and it has been, I would say, a labor of love for a while, and hopefully we will see something come to fruition from it. But in contributing, I would like to speak about one of the things that Emma raised around whether writing the judgment at this stage, the utility in it when the Public Order Act has been repealed. And I would agree with Emma in understanding that while even if the problems are themselves no longer a problem, it is worth appreciating that when these judgments are being rewritten, it's from the lens of what was available at the time. So the tools that were available at the time. So it's not that we're going to rely on anything new, any new knowledge, but whatever tools are available at the time with a different lens, with a different set of knowledge could lead to a different outcome. So this is to say that even though you can have a repeal 10 years from now, the argument is you could have had a different outcome 5 years ago had you taken into account gendering your approach. So it becomes important, whether or not there has been social change in other ways, to appreciate that the judiciary does have a role to play in, one, thinking through their own bias, because as we all appreciate, the law is not the law is not free from bias, neither are the adjudicators of the law free from bias. Thinking through their own bias, both now, in the past, and in the future, and then being able to, having recognized their own bias, see what would be different if that was not a lens that they were utilizing. And then what other lenses are available for them. And this really is the crux of this project for me. Being able to see, with the tools that you had, could you have come to a different outcome? And if you could have come to a different outcome, why didn't you? And if you can find the why consistently, we can help shape our world in a better way. But thank you for the opportunity to contribute.
So important, definitely. Thanks for that reminder. And then I see we also have a hand from Jawida. And we have a comment from Yaye. Maybe we could cue in those two, and just checking if there's any of our Francophone participants or Lusophone that would like to speak in that language, let us know and we'll just switch as well. Over to you, Jawida. Hi, Jawida. Okay. I think they're still opening up, but we have a comment from Nadia. Rewriting in the chat box, the rewriting of a judgment is also an objective interpretation of the law and not a subjective one, taking into account the constitutional principles of equality and non-discrimination, the evolution of society, particularly in family disputes and sexual assault against women. I'm not sure if Nadia, you'd like to also unmute yourself and just elaborate on your point. Hi, Nadia, I see you're unmuted. Over to you. Okay, Nadia is speaking in French, so if we can switch to the French channel. Go ahead. Okay, I think there's a connection challenge there. Okay. That's okay, thank you. But we also see your comment, Ayaye, hello. Right. I don't know if Yaya would like to speak, but the point that they're making in the chat box is maybe it's due to connection cuts, but not really understanding why the rewriting of the judgments. It has the aspect of res judicata. Our problem in Senegal with discriminatory laws against women tend to disappear because of the hard work of humanists, feminists, men as well as women. It is rather the application of the penalties enacted for certain violations at the national level and at the regional level, the lack of knowledge on the procedures or referral to the jurisdictions. Is there a panel member who'd like to respond to Yaya's question?
I'm not sure, but I think they were probably responding to Emma's case that because it has the aspect of res judicata. Yeah, I'm not sure about the res judicata point actually, but I think maybe they meant that the case has already been, the statute has been enacted. But I could be wrong, I'm not sure. But I think I would like to go back to Nerima's point before about the fact that even if the subject matter has already been dealt with in a previous judgment or things have moved on, there's still a point of some points that need to be made, contextual points, for example. And I was trying to remember the case, the abortion case in the US. For some reason, it's not coming to my mind, but it's very famous. But I was thinking about the fact that as feminists, we shouldn't be complacent, is it? That even if we feel that we've achieved a judgment or a favorable outcome, things can as well turn around, right? So I don't know if anyone remembers the case, if anyone just wants to say it or write it in the chat. But the fact that that judgment has now, in the US, has now sort of been, it's Roe versus Wade, yes, Roe versus Wade is now, so it has been celebrated, sort of been one of these landmark judgments in the US, but look at what's happening now. So I think the point I want to make is, even if we feel like the subject matter is no longer an issue, we shouldn't just relax and say we've achieved it, because depending on the politics of the day, things do change all the time. So we still must be vigilant. And I think that the fact that we have a record of a feminist judgment means that even when a judge wants to overturn a previous judgment, they have the benefit of reading the written feminist judgment. And personally, I would be very averse to, personally as a judge, if I know that there's already a written feminist judgment, I really have to go above board to explain why I would reverse a previous judgment. So I'm not sure if I've dealt with their question exactly, because I don't know whether it was dealing with Emma's case or not, but I think that's, right. Yeah.
Thank you. And I think the other general question around res judicata, if just to make it clear, is, we are rewriting judgments, not so much to give remedies, to the parties before the court, because the matter has already been determined. The idea of the rewriting process, as we said earlier, is an imagination project. Really, we are saying, here's a problematic judgment. We are not the court, but we are feminist lawyers who carry our expertise in, understanding the law, but also our feminist legal methods and the ability to critique the law and make it work for women or change the law. So we bring that analysis to that judgment to create a product that can be used to imagine what the law actually should be in a way that sees women, protects women, enables women to live their lives with dignity and full enjoyment of human rights. So it's not, determining the matter. It's really an exercise in applying our feminist analysis to imagine what the world should look like, as opposed to accepting what it is. So I see we've come to the end of our webinar. We've right on the mark, but we really are grateful to all of you for showing up, for making the time, for engaging in the chat box, for speaking, unmuting, and sharing your thoughts with us. In the post-webinar communication, we'll share with you highlights that came from this webinar, and also the link to LUC platform as well, so that we can continue engaging further. So I would just want to give the panelists a minute each to wrap up. Any closing words, any action points, how you're feeling the space was and what's going to move us forward. And I'll start with you, Emma.
Thank you. Thank you, Nekura, and thank you so much for the invitation. I think my sort of biggest takeaway, and there's a lot of points that have been pointed out, but I think my biggest takeaway is linking up with part one of this particular webinar, which was the launch of the platform. And I think just because the African Feminist Judgments Project has been uploaded and it's part of this particular platform, I think my biggest sort of takeaway, at least my petition, is that hopefully once we start writing the particular judgments, then we would have interventions, especially from social movements and legal practitioners coming in to really critique the particular judgments set up in the platform, so that I think the biggest takeaway is just to see how all these things can come together in such a lovely way, and hopefully the platform really providing a solution to some of the queries and some of the drawbacks that we had identified when we first conceptualized this project all the way in 2018.
Amazing. Thank you, Emma. Over to you, Dr. Martha.
Thank you, Dr. Ruth Nekura. Yes, like Emma, I would like to go back to part one of the webinar and reflect on collaboration and the fact that the Judgements project is now part of that collaboration. And I think I would also like to reflect on the fact that I'm not only a member of the project, but also an academic in a global North institution. And so I am really fired by the vision about pedagogy. I think that there are real interventions by feminist academics, especially to use feminist judgments as teaching tools. So in that sense, the fact that it will be on the platform, and it's one of the ethos of the project is open access to the judgments. So I really see an intention to use them as teaching tools. But I think also I've reflected on the fact that we can also collaborate on how we teach our students between the global North and the global South. So I am still thinking personally about how to do this exactly, but it's a reaction to my own fieldwork, where the culture of going to Africa to carry out fieldwork and then getting your material and going away and sort of not having any further connections with the participants. I think that in terms of not just pedagogy, but research ethics as well, how do we collaborate with beneficiaries so that we don't just see our participants as beneficiaries and users of research, but also we don't just take things from participants, if I may use it that way. We don't see participants as giving us data, but as users of our research. How do we collaborate in that? How do we write grants as academics that center activists and social movements as collaborators and not just as data, as sources of data? So I think in terms of pedagogy and research ethics, reflecting on these two and how we could collaborate more. So that's my reflection.
Thank you so much for your honest reflection and suggestions, Dr. Martha. Sibongile. Hi, Sibongile. What's your parting shot? Closing reflection.
Okay, the program project started a few years ago, and as said in the beginning by Ambrina, we, for a whole range of reasons, we haven't been able to finalize and kind of develop it, but it's not a project that we see as capable of being completed. Of course, there will be the first part that is done, the publication of the book, but what we are asking for more than anything else is people to keep vigilant, of decisions, like this. And I think what the LUC platform is for is, even if you cannot write the decision, right, because you don't believe that you have got the expertise and the skill, I think it will be helpful, to post those decisions and say, from my country, this is what has happened, this is what they have done. And hopefully as the network grows, the writers can go, to the platform and find, those cases. So I think there were questions here about what can other people do, and I think that's one of the most practical things that we can ask ourselves to do. So kind of going forward, I think the idea of collaborations, I'm very happy to see people from Benin, from Burkina Faso and all of that. Our work in Francophone Africa and West Africa is really new. We have real presence in Burkina Faso only. And the divide on the continent is not only because of the legal systems, civil law and common law. Language has been a really big problem that really frustrates our collaboration. And what I can say there is what we have done as ISLA is to create a platform that is available in English and French, and with the hope that we can go and develop it further, so that it includes other languages. Unfortunately, most of them are colonial languages. I think it's East Africa that's really getting it on, Swahili, and hopefully all of us will get better. But I think just whatever it is that you see, because what should happen to us, and this is something that we normally say to the people that we work with, we have to have a sense of justice that can be triggered, right? So whether we are listening to a news report or whether we are saying something has to be able to say to us, but this decision is wrong. And then that sense of justice, when it gets triggered, it should compel us to act, and I think it's how the systems, the authorities have really tried to tire us, because we don't have a shortage of things that outrage us, trigger us on an ongoing basis. And this is one way, when I think of LUC, that can help us channel, especially the violations that come from the people that we expect, to hold others accountable, for violations. So when systems like courts fail us, it is understandable, that you just want to go and sleep, you don't want to think about it, because what does it mean to spend months developing a submission that's going to go to the court, and you read the decision and it is very clear to you that the people that I am talking to and do not understand what international human rights standards are, because then where is your site, of struggle? So we will get tired, and that is to be expected, because it is a lot and it does get too much. And when you get tired, it's not going to take you a lot of time to forward the decision to Cynthia, or to just put it there, like park it there, you know, and someone can be outraged into action.
Absolutely. Thanks for that. And we'll put in Cynthia's email on the chat. Actually, she's available and she has said this to share information, receive information from you, questions, interest, and thank you. Thanks, Cynthia, for typing in your email. And yes, over to you, Prof.
Thank you so much, Dr. Ruth. Just to add a few things. One is, I think we have to do everything we can to make sure that this is a Pan-Africanist project, that we speak across that we speak in common, that we see the benefit of doing this work across a number of jurisdictions, and that we overcome the really substantial language barriers. I think this event has been such a good example of how we can start to do that. I think it's absolutely critical that we do that we don't allow monolingualism, particularly our kind of Anglophone tendencies, to cut us off from each other. So it seems to be those two things go hand in hand, multilingualism and Pan-Africanism. Just to clear up a couple of questions that I've seen coming up in the chat about whether we call this a rewriting project, and I would really firmly say yes, we do, because that's precisely what we do when we take on board a judgment. We are rewriting it. We are showing, using the exact same structures and conventions of the law, how things might have been otherwise. You could even rewrite a judgment that reaches exactly the same outcome, but by a different route. In other words, you're showing your reasoning. You're focusing on the reasoning. And that's why we call it a rewrite. Yes, there is a place for analysis or for critique or some of the other words I've seen being used in the chat. And they're really very important, but they are either prior to the rewriting of the judgment or, you know, after it. It's an organic process. Anyone is welcome to take a rewrite and then, or you yourself as the author can provide an analysis alongside a rewrite that explains your thinking and the way in which you approached it. So I would stay very closely aligned with this language of rewriting a judgment, and then I would see the platform as giving us this possibility of archiving our work. The platform is a real life thing. As Sibongile says, it doesn't end, but what it does is provide us a way to have a real organic kind of archive of our work. So in relation to any given judgment, it can be rewritten, it can be analyzed, the rewrite can be critiqued. It is possible then that it's, for example, translated and made available in another jurisdiction and used in that jurisdiction, and an account is written and posted on the site about how it was useful to another jurisdiction. I would love to see, you know, a case on the 2/3 gender rule, sexual minorities, or whatever from Kenya made use of in Senegal and discussed on the site in relation to how it was used and how it's growing organically. And just to finish, I suppose, to add, you know, if there are particular cases that come to our attention, which we may not have the capacity to rewrite, but that we think deserve that kind of treatment, we should also use maybe the platform as a way to bring those to each other's attention, so that it's a constantly growing organic effort on our part.
Thank you so much, Prof. And our panelists and participants, thank you so much for being active and for sharing such wonderful insights that I know will continue this project moving forward. As you've heard, the vision for the African Feminist Judgment Project is abundant. It is collaborative, it's sequential, it's long-term, it's open, it's intended for, you know, the balance between conventional judgments that are rewritten for purposes of practitioners and judges, but also other outputs. It's intended for connection with civil society in pursuit of the change that we seek. And most importantly, I think I'll just end with something Prof said upfront that it's urgent. Our work is urgent, and we can't really afford to not move, even in small steps. So thank you so much for making time and for joining us. Yeah, and that's the end of the webinar. Bye.
Thank you. Bye-bye.
Bye.